Welcome to the weekly press briefing of the Kosovo Specialist Chambers, where we aim to provide journalists with an update on the latest developments at the court and the opportunity to ask questions. On the 15th of May, the trial panel in the case of Hashim Thaçi, Kadri Veseli, Recep Salimi, and Jakub Krasniqi decided on 2 registry reports on victims' participation in the proceedings. In their decision, the judges granted the applications of 4 victims to participate in the proceedings and rejected the application of 1 victim. The KSC rules allow for the judges to accept applications after the deadline when good cause is shown. In their decision, the judges explained their reasoning in accepting the application for each of the 4 victims. The 4 victims will join the group of participating victims represented by Victims' Counsel Simon Laws. 156 victims are now participating in the proceedings in this case. In the same case, the trial panel decided on a request from the prosecution to admit the written testimony of 5 witnesses under Rule 155. This rule allows the judges to admit into evidence the written testimony of a witness who is unavailable to appear in the court or subject to interference, if certain conditions are met. For one of the witness testimonies proposed by the prosecution, the trial panel rejected the request. The trial panel admitted the testimony in written form for the 4 other witnesses, noting in each case that the evidence of the relevant witness was not directly related to the acts or conduct of the accused as charged in the indictment. The trial panel also stressed that a final assessment of the reliability of the admitted testimonies would be made in light of the entire body of evidence admitted at the end of the trial. In the case of Hashim Thaçi, Bashkim Smakai, Fadil Fazliu, Isni Kilay, and Hayrudin Kutsi, the pretrial judge extended the deadline for the prosecution to respond to defense preliminary motions. This followed 2 extensions granted earlier to the defense. Before the start of the trial, an accused has the right to file preliminary motions before the pretrial judge, in which they may, for example, challenge the jurisdiction of the specialist chambers or allege defects in the form of the indictment. The defense teams have filed 5 preliminary motions in this case. The appeal hearing in the Pietrushala case concluded last Friday, the 16th of May, following the submissions by the parties and the personal address of Mr. Shala. Among other submissions, the defense stated that the convictions should be reversed and their client acquitted of all counts, while the prosecution argued that Mr. Shala's appeal should be rejected in its entirety. The Court of Appeals panel will render its judgment in due course.